Welcome to the Same Day Podcast, where we discuss driving incremental business growth and other topics related to real estate, property management, and entrepreneurship. Now, to the show at hand.
Hi there, Yoni Schmidt hosting today's episode of the Same Day Podcast, where I connect with top business and real estate leaders. Past guests include Chip Gadrino, a local restaurateur entrepreneur, Elliot Nelson, the CEO of the McNally's Group, Morgan Martin of Merrill Lynch, and many, many other interesting people. Today's episode is brought to you by Keyrenter Property Management. At Keyrenter Property Management, we are a full-service property management company helping our clients buy, renovate, and operate real estate assets. We help our clients build wealth while taking the headache out of property management. That is why no matter what rental you have, a single-family home, a condo, a townhouse, or an apartment, we have the management solutions for you. Go to KeyrenterPMC.com or email us at info@KeyrenterPMC.com. Today, I'm excited to welcome Monica Gilroy, a nationally recognized real estate attorney and managing partner of the Gilroy Firm based in Atlanta. With a legal career spanning over 3 decades, she's a subject matter expert in property management, law, fair housing, and real estate litigation. Monica serves as general counsel of the Atlanta chapter of NARPM and is a highly sought-after speaker, educator, and advisor to property managers nationwide. Her passion lies in empowering professionals to navigate complex legal issues with clarity, integrity, and confidence. Welcome to the show, and thank you for being here.
Thank you so much. I'm excited to be here.
Monica, you are a powerhouse because I literally read your article maybe 3 or 4 days ago. The same second I read it, I emailed you. Within, I don't even know how long, hours, you responded and we got this podcast recorded. So thank you so much for working at the speed that I'm used to. And so the article that I'm mentioning is the Single Family Residential Property Managers and ICE, a PM's Perspective, which we actually shared with our entire business, 100 and somewhat employees, because we understand that at a certain point in time, there may be interaction between our property managers, our senior property managers, and employees within the business, Keyrenter PMC, and ICE agents. And so let's start with the basics, I guess. Can you explain a little bit maybe about the difference between an ICE administrative subpoena and a judicial warrant, and why the distinction is so important for property managers specifically?
Yeah, absolutely. With the increase in ICE enforcement across the country, there's a lot of misunderstanding as to exactly what ICE is and cannot do. Of course, ICE, is immigration and customs enforcement. In certain areas of the country, very, very active. And the concept is that ICE is empowered under their, for so to speak, charter to be able to obviously find individuals who are deemed under the law to be dangerous and here illegally. But what we're seeing happening in certain sectors, and especially the rental sector, is we could see ICE coming in with what is just simply called an administrative subpoena. It's almost like just a list of information that an ICE officer may come in and ask for. Usually it's things like, addresses, information about your specific tenants, perhaps your onboarding file, what you had, things like that. But the thing that's important to remember about an administrative subpoena, and maybe that's sort of the way to think of it, is administrative. It is not issued by a court, by a judge. It is simply, in essence, a request by ICE for information. And so because of that, that's why, and we could discuss this in more detail, you have to be more cautious about your compliance, how you comply, or if you comply at all. Now, versus what would be called a judicial warrant, that's going to be something that's signed by a judge. And that can come in a variety of forms. It can come in the form of sort of the warrants we think of, like in movies and TV, do you have a warrant to enter this property? But that's exactly what we're talking about. It'd be something that would be signed by a judge that some entity or organization has gotten a judge to sign off on, either the entering of a premises or to request information. Or it could be done even in a civil context, right? Of, it's not so much a criminal warrant, but it's a subpoena signed by a judge saying this is the information we need. And obviously that is very different because that is a court of law commanding you to do something. And because you are being commanded by a court of law, your liability as a property manager goes way down, right? As opposed to these administrative subpoenas that are not quite strong enough to actually force you to turn over this information.
Yeah, that's very interesting. So, which leads me to my next question. In your article, you stress that compliance, and you mentioned compliance with ICE administrative warrants is optional unless ordered by a court.
Right.
What is the biggest risk for property managers who do actually comply with these subpoenas? Or
Yeah, and that's a great
administrative, yeah, subpoenas.
Exactly. No, that is a great question. And that's where, it gets really dicey because we start getting into our fair housing field. And, depending on what state you're in, like we were talking earlier about the states your Keyrenter folks are in, those are states that could be heavily targeted by ICE officials. So yeah, there is nothing that requires you to just stop, drop, and do what you're doing and turn everything over to an ICE official. It is something that if you said to them, "Oh, I don't feel comfortable doing this," or "I want to speak to my own attorney," they might turn and leave in a huff, but there's nothing they can do. You cannot be thrown in jail. You cannot be penalized. And ICE can go back to a judge, come back with the warrant, but then there's even a process for you as a PM to decide, okay, am I going to push back on this? What should I do? It is not like even if ICE comes back with something signed by a judge that you automatically have to then comply. I've always advised that you should, first of all, even at the first instance of ICE at your door, you should always reach out to your own local attorney if you have one, or at least, someone that you trust within the industry to just get advice. The dangers of just voluntarily complying with the ICE administrative subpoena just right at the knock on your door is that you are getting into fair housing. Obviously, fair housing protects country of origin, right? It protects color, it protects race, color meaning color of your skin. And if we suddenly start just turning over information willy-nilly or saying, here's this, here's that, it could lead to a fair housing claim down the road by the person that you're providing that information to. Secondarily, you are turning over highly sensitive information. If you are being asked for bank account information, if you are being asked for anything else from onboarding that would contain something that's private towards the individual, every state in the United States has privacy laws, has privacy concerns. You can't disseminate private information, banking information about others just without doing anything. So it just opens up a really dangerous Pandora's box of liability for you, all based upon, in essence, a document that isn't really even enforceable on its face. It requires more.
Interesting. So us as property managers, and I know you work nationwide, but you're based in Atlanta, us as property managers in Oklahoma and Arkansas and Wichita and Missouri and Kansas, right? There's a certain level of responsibility that we have when we are holding all of this, confidential information. If we hand it over to an ICE agent, there then becomes a certain level of potential liability that, we may then be sued because we provided, private information that wasn't supposed to be handed over without a judge's court order.
Exactly. Because you have to think of it like, what if that ICE request is wrong, right? What if there's a belief that this person, falls into the category of ICE enforcement, but yet it turns out they don't, right?
Right.
And you then become, as a company, a target for both that individual who potentially has problems with ICE or is improperly detained or whatever, but also their family. Think about that for a minute. What if they're targeting the father, right, of a family of 4 who live there, and you turn over everybody's information, and the wife, I mean, that's a huge problem. The wife is not subject to an ICE investigation. You've just literally handed over to, in essence, like a complete stranger, somebody's private information, which, if we think about it logically, if I was a stranger and I knocked on the PM's door and I said, give me your file on Tenant John Smith, you wouldn't do that. You'd be like, no, why? Show me a subpoena from a court. Show me this. So that's sort of how we have to think about it. Now, that being said, though, we are not ever to be obviously disrespectful to ICE. We are to take this seriously. But we do have the ability to say, no, I know that you have to have an actual, signed warrant from a judge before we move forward. And again, even then, if the scope of the request by ICE has to be narrow enough, right? It can't be just like, give me everything you need. It needs to be more specific, right? So if there was specificity, you can go ahead and ask for that to be broken out. when you're in front of a judge dealing with a nice administrative subpoena to get more clarity to further protect you so you're not just turning over too much.
Yeah, love that. You just answered my next question, which was how should a property manager respond in the moment that an ICE agent shows up at their office with an administrative subpoena or a warrant.
Take a breath.
So
take a breath.
take a breath.
Take a breath. Take a breath. Think about it for a minute. Explain to them that, I would say, thank you. But I need to consult with my own attorney on this. You have every right to say that. Again, you will not be in trouble if there is obviously any type of, suggestion of, coercion, or this is, you have to do this. No, that's not what the law says. You have a right to take a breath. So I would say take a breath. And then, and then again, it's very important. And this is true really of any subpoena in general. If you got one, even in the context of a court hearing, just only give what is requested of you. That really limits your liability. Don't give over too much.
Yeah. Well, so taking a breath is very important. And hopefully they read your article and they've listened to this podcast before, the agents, showed up at their door. But for property managers who are trying to do the right thing under pressure, because there's a lot of pressure if, ICE agents show up at your door, you don't know how they're going to show up. They could show up in force. They can show up, in masses. What's your best advice on balancing tenant privacy with, law enforcement requests and also respecting law enforcement?
Yeah, that's a great question. I mean, I think always, and this is true of anything we do in our profession, but whenever we're dealing with any sort of legal situation or quasi-legal situation, we should always just be as professional as possible. We should never get upset, right? I think if ICE is being persistent, I do think you just have to garner everything you can from within and say, I have got to take a minute. I need to consult with, my advisor, my legal counsel. If they ask them politely to give you even 48 hours to do all of this, because just thinking about it, I think will hopefully, have it be something that then can get you to let you have a little bit more control, right? Okay, what am I going to do? You also can you can also ask flat out, okay, I understand that you're here. Is this a judicial warrant? Is this signed by a judge? Because if it is, that's how really the introduction should start, right? The knock on the door. We're here. This is signed by Judge Smith of the, the District Court of Kansas, then, okay, that's a very different situation, right? But even then, even when you're sent a subpoena from a judge, right, in a civil or criminal context, you always have time to gather your things and comply. I haven't heard from anyone yet in the industry that there's been a situation where ICE has come to the door and just stood there and said, give me everything now, right? Asking for time is completely appropriate, especially when it's not a judicial warrant. But even in the context of something that's judicial, you're always given time to gather everything. Because what, again, you want to do as a PM is you don't want to overgive, right? If the warrant says, I want their banking account information, but it doesn't ask for their employment history, or vice versa, it wants their employment history, but not their banking information, don't turn over too much. Don't turn over that banking information, because again, that's where the private things, the invasion of privacy and the dissemination of private information can really get you into trouble. So, it can be a little intimidating, but I think just asking for that time, but also just saying, is this a warrant? Think about it almost like when you get pulled over by a policeman for a speeding ticket, right? When you get pulled over for a speeding ticket, you're supposed to sit there with your hands calmly on the wheel. You don't go, oh, I'm so sorry. What did I do? You're very polite. You're very businesslike, but you can certainly say, how fast was I going, officer? Right? That's like asking, is this signed by a judge? So sort of think about it like that. Like, how would you react to other interactions with, forms of law enforcement? Because most people haven't had that, except for things like traffic tickets, or things like that. So, but that would be my advice, is just to really, don't hesitate to push back, ask for the time. And then again, it helps you, even 48 hours would help you to get some advice, right? Even if it's just from your local chapter leaders to say, hey, what's going on, or from a lawyer, anything like that.
Yeah. Wonderful. Thank you for clarifying that. I mentioned earlier, we shared we shared your article with our entire staff, for training. From your perspective, what are the most critical steps that every property management company should take to prepare their teams for handling these scenarios?
That's a great question. I would say two things. It is never a bad idea to have a fair housing moment every single month. Fair, I teach and speak frequently on fair housing across the country. And even when I do this to groups that I know have had the education, people will come up and say, I learned something new today. So your staff, and when I say your staff, I am talking about from the tippy top staff to the very lowest person you have working in your company in terms of seniority, but especially your onboarding people. They have got to know fair housing inside and out. They've got to understand, especially in this arena, what race means, right? What does the protected class of race, what color means? Color is one of those issues under fair housing that people get really confused about, but it's making an assumption based upon the color of someone's skin, right? It's looking at them and saying, oh, they must be from this country because of the color of their skin, right? And then, of course, national origin, the country from which you came. That's really at the heart, right, of what we're talking about with an ICE investigation, is that they're targeting people based upon those three things, right? Race, color, and national origin, because obviously they're believing that they're not here legally in the country. So if we can understand why our job as PMs is to be sure we're following fair housing, that's the number one thing, right? Because that gives a bigger perspective, I think, as to why we're able to say, no, wait a minute, let's be careful about this. And then secondarily, just like an article like mine or anything else that's a current event, right? Just be sure, even once a week, you let your staff, even if it's just a blast, you should be reading the news yourself, right? If there's something out there that just, is national in scope, or if it's in your state or something happens, share with them the current event trends, help them connect the dots between our current legal and political environment, right? And what is going on in their jobs every day. It really helps bring context to it. And that was sort of the hope about this article, is that, we had enough inquiries from folks saying, I'm not quite sure about the differences in these subpoenas and what do I do? And, it makes a difference to just, sharing information like this, but really always going back to the foundation of fair housing, to be sure everyone understands that at the heart of this, that's where the real liability lies, that and giving out private information. And honestly, even a third thing would be reminding them about private information that, just like we tell our elderly parents, don't give your credit card number over the phone. That's the same concept, right? You're not giving out voluntarily private information about others, and being sure the staff understands not just why they shouldn't do it, but, the why, right? Why are we not doing this? We are safeguarding private information, and we expose our company. We maybe even expose our owners, depending on the nature of the relationship, right, to liability. And we don't want to have that happen.
Could a PM on the personal level be exposed to liability?
Well, that's the thing, is that nowadays I see fair housing claims, I see lawsuits that name the PMs by name, right? That they interact with Betty Smith, and guess who's named in the claim, right? It's Betty Smith. Now, usually usually in my experience, the companies, when they are named, will take care of their staff, but at the same token, do you really want personally to have the stress of being named in some sort of lawsuit or fair housing complaint? Although your liability would not most likely be individual, people all the time, people do whatever they want to do and they get mad. They name anybody and everybody. And so you don't ever want to see your name on a piece of paper like that.
Yeah, I would imagine. Let's talk about how this topic intersects with like local or state level laws that may protect immigration or citizenship status, right? What should property managers, do? Should they assume the strictest standard applies?
Yes, I would say so. Like if and I will say, it's not, there are only a handful of states and jurisdictions that would have kind of an interactive, law or regulation that deals with what we're talking about today. Most states are going to be dealing just with the federal, law. They're not going to be seeing interaction from an ICE equivalent, right, on a local level. But yes, you should, kind of the same rules apply, right? Take a moment, take a breath. What you might find, though, more likely on the local or state level is you might find something actually signed by a judge, right? There may be a little more oversight, right? That if some authoritative body wants this information, unlike ICE on the national level that may come in with the administrative subpoena, someone nationally might come right out of the box with something that we would consider to be valid, enforceable, right? It would be, again, something that could be civil, issued by someone civilly, or even on a criminal context. Because again, seeing that signature by the judge, that is a different reaction, right? That is meaning they've already been to a judge. Now, that being said, there are still things that can be done by a property manager if they feel that there is maybe too broad of a scope, right? You should never ever ignore a subpoena signed by a court. That is a very serious document. That is something that's summoning you, right? Subpoena is a Latin word for summoning, right? To bring you in, right? To obtain information. So it is still an order of the court to you. Now, if there are questions and you need clarity, you're able to go back to the court and ask for that. But that would be my thought, is that we might see on the local level actually, a little bit more of the formality of having something signed by a judge. And let me add this. When you have a judicial subpoena, right? Something signed by a judge, your liability as a PM is pretty much absolved, right? You are clean because you are being ordered by a court not to do it. There are, not to get too legal, but there are mechanisms, right, that people who are the subject of a subpoena they're called stopping, right? Stopping subpoenas, right? But you are, at that point, you as the PM, you're just sort of over here, you're just sort of the bystander who has the information, right? And if there's nobody saying, no, PM, don't give it, you can give it without the fear of the liability. Saying that I was subpoenaed really provides like a shield almost of liability to you because you were being compelled by a court. Because if you don't do what the court told you to do, then you're going to get in trouble with the court. You're held in what's called contempt. And again, that's like we think of movies and TVs, I hold you in contempt. That's exactly what that means. It means that you haven't followed a direct order from a court. So, it makes sense to think of it that way. But I do know that there are certain places in the country where, yes, you're going to want to defer to what your local level is, right? Because that would potentially override what could be happening federally.
Interesting.
That's a great question.
Thank you. Do you see trends or increasing legal exposure for property managers as immigration enforcement becomes more visible? What should PMs be watching for throughout the rest of the year and into 2026?
Yeah, I mean, I think it's hard to know these days because there's so much. I was looking at something the other day about the criticism in, for example, Washington, D.C., where the ICE individuals are wearing masks, face coverings, and they're not able to identify themselves because of their own fear of safety. But yet that poses a whole nother sort of wrinkle in this, is that what if someone showed up in a mask to your PM door and didn't have any ID? You've got to just be able, I think, to be on top of what's happening in the news, on top of the trends. I think assume for now, ICE is here to stay and ICE enforcements will continue. I think that, the frequency and the nature of it are going to be very much geographically based. Where are you located? Where are you practicing? It might be very different for someone in, the Midwest as it might be for someone in the Southwest. But I think that we're going to have to assume that this is going to continue. And so staying, abreast of the topic, feeling comfortable with what to do in the process is really important. And the other thing I would say too is, you've got to be careful as a PM about not giving legal advice to your tenant. So if the tenant comes to you and says, oh my goodness, or if you tell the tenant, okay, ICE came today, because that's what you should do. If ICE comes and you turn them away, be sure the tenant is aware. Don't keep that secret, friends. Be sure you tell the tenant, hey, they were here, right? And the tenant says, oh my goodness, Miss PM, what am I supposed to do? That is not where we give any legal advice. We want to be able to say, I cannot provide legal advice. There's every city in America has a legal aid, a volunteer lawyer foundation. There are groups that are set up, many groups that are there to help those who are the focus by an ICE investigation. That's where you should direct them, right? And don't make any promises. Don't say, oh, I won't do this, I won't do that. Just, you have to explain that, well, I know from what I've learned, this is a process. I am not required to turn anything over unless there is a court order, a subpoena. But you, Mr. Tenant, need to be doing what you need to be doing to take care of yourself as well. And that can be really hard, because what if it's like a longtime tenant that you really care about? And, your tenants are your biggest assets, friends. They are, right? Keeping a good tenant is the best way to make money in property management, but you still have to be careful, because you just don't want to find yourself in that gray space of, providing legal advice, or, finding yourself in a non-compliant status with a court order.
Yeah, definitely. The tenants pay our salaries. Without them, we don't charge management fees, and the industry doesn't really exist.
That's right.
I'm really glad you touched about legal advice, because my next question here is about that. You've had a long and impressive career advocating for property managers. What is, aside for the legal advice, I guess you may have just given us about not giving legal advice to tenants, what's one piece of legal advice that you think every property manager should keep top of mind, regardless of the issue?
So regardless of whether we're talking about anything at all, okay, your documents control. Okay. And this is why your documents, your property management agreement, your lease, your policies and procedures are critical. Because if your property management agreement, right, doesn't give you the authority to do something and you do it, you've just breached that agreement, right? You've got to know your documents that you operate under. You've got to follow them, right? Which is why I always advocate for example, property management agreements. I advocate that you have, language in there that limits your liability as a PM, that provides what's called exculpatory or, CYA language, right? To be sure that you're protecting yourself. I have seen a large trend over the last few years of owners getting mad at property managers because of failed tenants, right? A tenant that was a fraudster, a tenant that wrecked the inside of the property. And they blame the PMs for saying, well, you put that person in there. How come you didn't know 3 years ago when they had a 800 credit score and were the president of this big company and had a perfect history that they were going to, lose their job and, half burn down the house? Well, we can't know that, right? But limiting what our jobs are, right? Saying in our contracts, my job is to find a tenant, screen a tenant, manage a tenant, things in our documents that say what we're supposed to do. That is the number one way to avoid liability. It honestly is. Just have your documents be very tight in terms of what you do, what you can do, and then be sure you follow them, right? Be sure that you are doing what you're supposed to do. Keep your staff always trained on those things. But to me, that is probably the number one thing, because if we can always take the classes, right, about the fair housing and lead-based paint and all that stuff. But at the end of the day, if our documents, our foundational documents, where we start our jumping off relationship with our owners and our tenants, if they aren't good and don't have language that really helps define what you're doing as a PM, I'm a pretty good lawyer, but it's hard sometimes when I have a really bad document.
Yeah. So would that be the indemnification clause that you would include in a property management agreement?
It's indemnification, but it's more than that, right? It's what's the scope of my job, right? Is it my job to know, as to you, Mr. Owner, that 5 years from now, that tenant is going to not fall into default, right? You're not controlling if your tenant defaults or if they ruin the property, right? If your documents say you are going to inspect the premises, the property every 6 months, well, then by gosh, you better go inspect it every 6 months. Because if you don't, and in month 8, there's a water leak and the house gets full of mold, suddenly you've just breached your obligation, right? So it's not just indemnity. It's doing what it's defining what you're supposed to be doing as it relates to the tenant and as it relates to the owner, right? If you're supposed to be giving your tenant as part of a resident benefit package, the insurance information, right? If they're supposed to know how to reach out to their renter's insurance if they have a claim, you better give that to them, right? If they're supposed to be doing something that you're giving them as the PM to the tenant, be sure they have it, right? If they're supposed to be putting in the air filters, be sure they know how to do that. I mean, it's doing the basic things that it says in the documents that you're going to do. And yes, of course, obviously indemnity is important. In every state, it's going to be upheld. We've talked about this in other forms, but indemnity can't be wholly one-sided. You've got to have some balance. But, again, to me, you don't even need to get to indemnity. If you just if you lay out, here's what you're hiring me to do, Mr. Owner, and no more. So that way, if something happens, that's part of the no more. I come into court and I say, Judge, here's what they're supposed to do. And they did all these things. Makes a big difference. Difference.
Yeah. Wonderful. Last question here that I have is for those who want to stay compliant and avoid missteps, how can they build a relationship with legal counsel that helps them respond competently when these issues arise, whether it's, what we just spoke about, whether it's the ICE issue in immigration and customs enforcement?
That's great. It's a great question. Obviously, I'm a big proponent of NARPM, and I think that a NARPM membership is great because it links you with many legal professionals across the country. There are, certainly good landlord-tenant attorneys that exist across the United States. There's also some people that are very focused on some of these side issues like fair housing and things like that. But it's good you always want to sort of know a lawyer in the event of emergency to just break glass, right? I have a lot of clients, for example, who come to me with the problem. We establish a relationship, all across the country for one problem. But then once we've established that relationship, it gives them an ability to, okay, this is bad. I need to call Monica now, or I need to call my lawyer now. You want to try to find somebody. There may not be a one size fits all attorney because, again, like I'm sort of like a unicorn. I'm sort of weird because I've been in the industry for so long. But but there are others like me, like Harry Heist out of Florida, an incredible resource. And many of these individuals have, national practices like mine as well. But you want to find somebody, even if it's just somebody, around the corner from you, that at least understands your state's landlord-tenant laws, right? And if you got some kind of nasty letter from somebody saying, you withheld the security deposit and you owe me all this money, that at least can respond on that behalf, right? It is always good as a business owner in today's business world to have legal counsel, just like you should have an accountant, right? A tax professional. You should not be dabbling in the law by yourself. You shouldn't be dabbling in the taxes by yourself. You shouldn't be dabbling in insurance yourself. Just have that as part of your team. It doesn't need to be somebody, it doesn't need to be somebody who's super big and fancy. It just needs to be somebody that you trust, right? Who can help you with good contract writing, but who also understands the landlord-tenant laws in your states. And having someone like that is fantastic. And then, knowing that there's other resources out there through NARPM, things like that. If the problem is bigger or more national in scope, that's great. You have lots of those, people as well to help on that national platform, especially through NARPM.
Yeah, wonderful. So be a part of NARPM so that you can access those resources.
Absolutely.
Monica,
and all the education. Yes.
Yeah. You've been such a wealth of knowledge, and I can tell you, I'm smarter just for having this 40-minute conversation with you.
Well, thanks for having it with me. I enjoyed it. It was great.
And I hope our listeners also enjoyed it and learned something new. If anyone wants to get in touch with you, what's the best way to do that?
The best way is to do it via email, which is mkg@gilroyfirm.com. Also, my website, the Gilroy Firm, has an entire page dedicated to property management. It's an incredible wealth of forms banks, educational materials you may need in your practice. And so if someone goes there to check it out, there's a lot of things they might find to be helpful in their business, as well as ways to contact me and my team.
Nice. We'll put those in the comments below so that you have easy access. Thank you so much for being here. I truly appreciate it.
You're welcome. Thank you. Have a great day. I appreciate it.
You too.
Thanks for listening to the Same Day Podcast. Tune in to a new show each week and be sure to subscribe to get future episodes.